What I want to do today is talk with you a little bit about what I want to call the constitutional politics of, of gun control in the United States. And I want to do two things. One, I want to explain what some of the cases on the federal district and circuit levels have been since the landmark decisions in Heller versus District of Columbia in 2008, in which the Supreme Court recognized that the Second Amendment that in the Second Amendment is a personal right to own some kind of firearm. Again, that's a personal fundamental right. And in 2010, in McDonald versus City of Chicago, where the court applied that notion of a fundamental individual right to own a firearm against the states in the way that it had always been applied to the federal government. So first, let me talk about some of the issues that have come before federal courts since 2010. And there's been a mixed bag in these cases. In other words, some federal district and circuit courts have ruled one way, and others have ruled in another way. And what that suggests is that the Supreme Court is likely to take up these issues, if not in the coming term, a year from now. To understand these issues, though, we have to understand what the court said in both the Heller case in 2008 and the McDonald case in 2010. Again, in Heller, a majority of the Supreme Court, certainly not everybody, a majority of the court ruled that the Second Amendment means that we have an individual right to own a firearm for self-defense. And again, in McDonald, they applied that right against the actions of state governments. In both of those cases, the court did not say that there was an inviolable right to own a firearm. In fact, even the conservative majority went so far as to say that there can be some kind of regulation of this right. We recognize other fundamental rights, some written in the Constitution, in the Bill of Rights particularly, and some not. And most majorities on most courts throughout American history have recognized that even while some rights are fundamental, that there can still be rational regulation of these rights. The only stipulation is that if they are fundamental rights, the government has to have, whether it's state or national, has to have a very good reason for any type of regulation of these rights. So what's been going on since 2010 is both pro and anti-gun organizations and individuals are trying to test the waters to see what the court really meant when it said that there could be some kinds of regulations on firearms. And those Heller and McDonald, they gave two examples. One example was if states want to ban felons from owning weapons, they could. And they had language in there in those opinions about restricting firearms from the mentally ill. But there are two other issues or areas that the courts have been split over in the last 2 years. One is that some states require that when you register for a gun permit, provide a reason or a justification for needing to carry a weapon outside of the home. So this would be a concealed carry permit. For example, you would have to say to your sheriff, if it's your county, for example, that issues these permits, you'd have to show cause why you should carry a weapon. For example, you might own a business that deals in cash, and you go to the depository every night, and you need protection. And the courts have split on this. Some have overturned this type of legislation, saying that it's too burdensome for the right, for this fundamental right. For example, you might have a justification for carry a firearm because you carry cash, because you run a cash business. But what if a year from now you don't have a business that requires cash deposits every night? If you don't have that justification anymore, do you still have justification to carry the permit? Some courts have struck that down. Others have upheld that. And the other question will ultimately be whether or not courts can ban or whether bans on weapons other than handguns are constitutional. And the court will inevitably hear cases like this very, very soon. And there are some things that we know about the way courts work, particularly the Supreme Court, that might come into play here. And this is where social science research might be able to tell us or give us some tools for understanding what the court or why the court might do or how they might rule in the future, especially considering that we still have fairly reliable 5-4 conservative majority on the court. It's quite possible that the court will uphold a lot of gun control legislation, either nationally or on the state level. And we've seen this in other areas of law, too, especially when a majority of the court seems to be sympathetic with a certain political majority. And that might not make sense if a conservative a court in which 5 justices were appointed by the Republican Party would vote against a Republican initiative, which would be to fight gun control legislation. But it might be the case, as we've seen in other areas of the law, where the court might actually help out the party, the Republican Party. It might be the case, and it's my feeling that it is, that a majority of Republicans do support some kind of regulation of firearms. Not a ban, of course, at all, but some do. But it's not, the political environment, at least within their own party, doesn't allow them to say that all the time. And it might be the case that the court could help them out, in a sense, and say that this type of legislation is constitutional.